I'm having a little trouble, and I don't know if you can help me, how we assess reasonableness when we don't know what they were acting on. And do we just presume they were acting in good faith without knowing the basis or structure within which they'd made that decision?
The Trudeau government's secret reasons for invoking the Emergencies Act. Hi, I'm Brian Lilley, political columnist for the Toronto Sun. For a week now, I've been saying that the Trudeau government wasn't trying to show that it met the legal threshold for invoking the Emergencies Act set out in the law. I've been saying that they have plainly claimed they had other reasons for doing so. I just didn't expect them to try and keep them secret, to actually tell the public inquiry looking into their invocation of the Emergencies Act that they weren't entitled to see those legal reasons. But that's what we saw on Wednesday when Justice Minister David Lametti appeared. Time and again, he was asked, what was the legal basis for invoking the Emergencies Act? The government has said that they looked at things far broader than the definition laid out in the Emergencies Act itself, or Section 2 of the CESES Act, which the Emergencies Act relies on. They said they looked at a far broader scope of ideas, of evidence, and of legal opinion. Well, what would that be? And time and again, David Lametti said he was invoking solicitor-client privilege, that he could not release this, since he's the government's lawyer, he could not release this unless the government gave him permission to do so. Here's his exchange with Justice Paul Rouleau, the leader of the commission, at the end of his testimony.
What was the belief of those who made the decision as to what the law was? And I guess the answer is we just assume they acted in good faith in application of whatever they were told. Is that sort of what you're saying?
I think that's fair.
Okay, because I think you understand what I'm saying, and I'm just trying to figure out how I get from A to B, because I'm close to starting to do that.
Rouleau is clearly frustrated. He's been asked to determine, was the government right to invoke the act? Was it justified? And he's been told, you can't see part of our reasoning for doing so. So just trust us. Is just trust us something that should be allowed here? Absolutely not. Solicitor-client privilege is important, but it can be waived. And in this case, this is the government saying, yes, we know we had to call this in public inquiry due to the law, but we didn't follow the law. In invoking it, we used other means. They should be required to explain what those other means are. There is no danger in doing this at this point. Most of their arguments for invoking the act have been economic. Well, economic reasons are not currently justified by the law. Maybe they should be, but that requires amending the law, not ignoring the law as it is written. Let me know what you think. Drop a comment down below. Share this on social media, and don't forget to subscribe to our channel.